Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada matters.
So today we're going to talk about property law. If you can give us just a breakdown, a brief description of what property law is about and how that can affect the consumer on the island.
Well, Ingram, you say properties law, that's a very wide area. But if I just narrow it down to what I deal with on a day-to-day basis, property law really on the island relates to land, and specifically property land that is owned by individuals' family. That is the concept really of family land. In the Caribbean, not only Grenada, family land is owned through the generations. So when an individual dies, rather than put the title deeds in the name of the present owner, the land, the title deed is usually left in the deceased's name. For instance, I have a client whom great-great-great-grandfather died in the 40s. So the land is still in his name. So the individual that actually owns the land now cannot mortgage or do anything with that land because it's not in their name. This causes quite a lot of problems. When I say problems, as I've said, if the property title deeds is not in the individual's name and it is in someone's name who died many years ago, that is open to abuse because any individual can take that title deed and put it into their name. That used to happen many times in Grenada because there used to be a system called Statutory Declaration. That is where the present owner completes an affidavit and then the title, the Statutory Declaration, to say they are the present owner. Nothing is displayed before the court. So when the ancestor, the family, goes to deal with that land, they find out that it is no longer owned by their family. This has happened so many times. So the law has been changed. In 2016, the Possessory Titles Act came into being. Under that act, the present possessor of the land, that's the one who's been living on that land, can acquire a title deed. What they need to do is to prove to the court that they have lived on the property and have acquired adverse possession. That means they've been on the property for more than 12 years. So if they can show the courts that they are in possession of that land for 12 years or more, they can obtain a certificate of title. And that certificate of title becomes their title deed, their first deed. This is a very straightforward process. As I said before, the Statutory Declaration, you do not go before the court, you just prepare documents, or your attorney prepares documents, and lo and behold, you're the owner of land. Is that quite clear? Right. The straightforward. The individual who is claiming that land, they need to obtain at least 2 individuals who are happy to put together an affidavit to show that that individual has acquired that land, that property, for over 12 years. When at least 2 individuals who have known that person for an unspecified amount of years, then that individual makes the application to the court. That application is like a notice. That notice is displayed in a minimum of 2 newspapers. When I say a minimum, it's usually 2 newspapers and also the Gazette, the Law Gazette. That is done twice on 2 monthly intervals. And the purpose of the advertisement is to make everyone know that that individual is attempting to or will acquire title to that property. It does not stop there, because after the 2 months twice advertisement, any individual who has an interest in that property may make an appearance to say they have a right or they know others who have a right in that property. When that occurs, there's a hearing before the judge. The individual who has requested appearance and the person who is requesting the title deed appears before the judge. In certain instances, the individuals who have prepared the affidavit is called before the judge to give evidence. So the procedure is available to all individuals, specifically who have lived on property for many years and do not have the appropriate title deeds. On many occasions, individuals do not come forward to contest the title. So in that case, it's usually very straightforward. The judge hears the matter. Sometimes when the application is straightforward, there doesn't need to be an appearance before the judge. The matter is signed off by the registrar. The registrar of the Supreme Court is the individual appointed under the Act who signs off after the matter is before the judge. So instead of individuals holding on to property that is in their ancestors' name, they can bring the register up to date and acquire the title to the property by way of possessory title, as opposed to the old way of statutory declaration. Because of course, under the statutory declaration, the banks are not happy with that system. So you cannot obtain a mortgage or a loan under the old system. So that is something that was enacted in 2016, which has been used quite often now to update the property system and laws within Grenada.
So, a couple of questions I'd like to ask you. First question I want to ask you tonight, Ms Willis, is hold on a second. First question I'd like to ask you is, I've heard stories of people that have lived in properties for a long time. They've been lodgers and then they don't want to leave, or they've been told to leave to move on. They don't want to move on and they stay in the property. And because they've stayed in the property a number of years, it's difficult for them to move them on. How does this work?
I'm unsure what you're actually saying there. Are you saying they are effectively squatters?
Yeah.
Well, yes, well, that happens. That is adverse possession. When you acquire property adversely, you possess it adversely. In that way, that falls under the Possessory Title Act as well, because that is a way of acquiring title, especially from the legal owner. Because if you have lived or acquired property for more than 12 years and nobody has disturbed you, nobody has tried to get you off the land, nobody has requested rent or any other monetary penalty for the property, you can, after 12 years or more, acquire the property under the Possessory Title Act, the same way as I have just mentioned, i.e. you obtain individuals who are aware that you have acquired that property or lived on that property without being disturbed for 12 years or more.
What's the most common misconception about property law, or people come in and tell you about property law that you have to correct them on?
Individuals believe if they pay the taxes for the property, they have acquired title. No, Just because you have paid the taxes, that does not give you any rights at all in the property in respect of title. As I've said, from 2016, to acquire title in that manner, you need to go through the courts. Because it's been long-standing from the Statute of Fraud Act, that is way back in the 1700s, 16 something. Property can only exchange hands if the owner puts his signature on the paper and that signature is witnessed. So if a person dies, the only way his property could be released is through the individual, either if he has a will, is executor; if he does not, is administrator; obtain probate. Again, probate is said there in a wide way, because if you leave a will, you have an executor that administers your estate. But if you do not leave a will, that means you've died intestate. You have not left a will. You have an administrator who administers your estate. And when that administrator or executor administers your estate, the deceased's estate, they step into the shoes of the deceased and able to sign in the absence of the deceased. That's the only way property could devolve, be exchanged.
Now, if the person, there's a will, then the person that is in the will, after there's been a death, is in the will to receive the property or own the property after the death, doesn't have a Grenadian passport, but may have a Trinidadian passport, but has got no link to Grenada. How easy or how difficult is it for them to own the property and then sell the property on afterwards? Or do they need to have a Grenadian passport if it's in Grenada or in Trinidad and they don't have a passport? Let me come back to you on that.
No, of course not. You don't need to be Grenadian or have, well, if you have a Grenadian passport, you're Grenadian national. No. If I'm living in Trinidad, say, United Kingdom, America, and somebody in Grenada leaves me property, I can acquire that property. I may need, if I'm not a Grenadian citizen, I may need to obtain a license. I'm trying to remember the actual name of the license. It will come to me. But you have to obtain a specific license to acquire property in Grenada. So you can, if somebody has left or bequeathed you property in their will, or actually made you an executor under their will, you can acquire that property. Because if you remember, if you recall, what is a will? It's a person's wishes on their death, how they want their property to be dealt with on their death. So the person appointed as their executor have their authority under the will. So they don't need to do anything further than obtain probate, and the property is vested to them. They can deal with the deceased's property.
Let me add to that another scenario. That individual has the property, they have the will in the property, and they have the top half of the house. But the bottom half of the house has got 4 different apartments. But each apartment has got belongs to a different member of family in that will. So the top half of the house belongs to the person that's at the will. The bottom half of the house belongs to other members of the family. So it's done that way to prevent it being sold. Now, if the top half wants to sell and the bottom half doesn't want to sell, what happens there?
Well, this is where it becomes litigious. You need to apply to the court. Because if you are the executor, you do have a power of sale. You can sell the property. But of course, if the deceased, which is also called the testator, that's why I pause because of the name. A testator leaves a will. It's his will. So you're saying the testator has 2-story house, say. He has left the top half to the executor, and who is also a beneficiary, and the bottom half to the other beneficiaries. It is best that a consensus could be had. That means they come into agreement. But if you recall, if somebody is giving it to you, they're bequeathing to you, it is yours. You cannot be forced to give away. So it also depends on the will, the way it is worded. Because the property could be leased. Because the land is freehold. And then the certain parts could be leased. It's quite a technical area. But to cut it short, the executor could apply to the court to partition the other beneficiaries' share of the property. Are you understanding? It's more difficult because you're saying the actual property. It'd be more easier if you say, if they had, say, 6 acres of land and it's for 6 individual people. That way, the executor could apply to the court with the beneficiaries for their shares to be partitioned, to be divided up amongst them. Is that what you mean?
If the property, each apartment downstairs, it's like a 1-bedroom flat. Each one's a 1-bedroom flat. And let's say the person who has the top room, top part of the house, wants to sell, and the people at the bottom don't want to sell, and the person top is forcing it, then they're all beneficiaries.
Well, that means you're creating a leasehold tenancy, are you not? Because you're saying it must be a very big place to have individual properties. You can partition it in that sense as well. Because you're saying for the executor to sell the house as one.
They could potentially want to sell the whole house at one. This is something that's, they want to sell the whole house at one, and other members of the family don't want to do that, and they don't get on. Then you have conflicting ideas. One just wants the money and grab, the others want to keep the property, and the person that did the will doesn't want the property sold. That was in their will in the beginning. How does that work?
Well, the executor is there to perform the wishes of the testator. But as you're saying, in not all cases, the wishes can be performed. But from what I'm understanding in the scenario, each beneficiary has a self-contained apartment. Yes, it can be partitioned that way into apartments rather than a whole house. That's where they have the Partition Act. And that comes into being as well. And that deals with a partition of property. Is that clear?
Very clear. The next question, I want to ask you about potential, or I've heard stories of government having the power to kick people out of their houses and claim property. Is this true or not? And what rights does the government have to claim property?
Well, you're talking about compulsory purchase of property. The government has a right if it's necessary. But of course, they are required to compensate the owner of that property. They cannot just go in, take the property and evict the person on the streets. They are required to compensate. That's in the Constitution, by the way. I'm dealing with that because everybody has a right to own property. So the state cannot just come and take that property away. But they can compulsory acquire it in specific instances.
Now, just to close off today, I'd like you to give us some facts or some things that people can take away from today's conversation, or in general about property law, and the most important things they need to know with regards to the subjects we've spoken about today.
Right, to me, the most important thing, we touched on it briefly. It's a whole topic, and I think we should deal with it another time for the whole of the broadcast. It is adverse possession. Because there's a lot of individuals, Grenadans, and in other areas of the diaspora, who have acquired property in Grenada. And they leave their property to another to look after the property, to build on that property, their property for them. But unbeknown to them, they give that individual certain rights over their property. And of course, they adversely possess that individual's property. So individuals in the diaspora who owns property, they should ensure that the individuals who are on their property are not just left there to do as they please. They should make sure they know what is occurring on their property. Because if they do not check on their property and the person is there having quiet enjoyment, that means left alone to do as they will, and even build concrete structures on their property, they will lose their property to that person. It has happened many, many, many times. And as I said, we should do a topic on that solely. That will come.
We can do a part 2 of this next week and follow up on property law.
That is a good idea.
Ms Willis, how do people contact you if they want to know more about property law and maybe have questions and issues that they may want to bring to you on the island of Grenada or across the Caribbean and want to talk to you? How's the best way for them to contact you?
Website h.willis.com, of course, www. Or they can contact me at my office on H.A. Blair Street.
Thank you very much, Ms Willis, as always.
Thank you very much for having me, Ingram. I've enjoyed the show, and I hope whoever is listening can take something away, digest it, and it will help them.
Again, Ms Willis, thank you very much. We'll see you next week.
Thank you.